Hello, everybody. Hello, Brett. How are you?
Hello, Shafik. How are you?
Doing well. Today we will talk about a very complicated issue, how to get off the sanctions list, especially from the US perspective. Before we start, I want to highlight some points about the Q&A boxes and that all participants can easily ask their questions on the Q&A boxes. And I would appreciate if you introduce yourself to the audience.
Sure. Hello, everyone. I'm Brad Henry. I'm a partner and vice chair of the White Collar Defense and Investigations practice at Blank Rome, a national U.S. law firm where I and my team practice typically on behalf of foreign companies and individuals related to their sanctions and export control, anti-money laundering, and anti-corruption work. That includes everything from compliance to dealing with subpoenas and requests for information. Of course, what we're talking about today, delistings, licensing, and all the way through to when there are enforcement actions. And so I'm very pleased to be here with you today, and thanks for the opportunity, Shafik.
Thank you for joining us, Brett. Brett, today I will ask you some questions from the three perspectives, the company perspectives, the sanctioned companies' perspectives, and the legal profession's perspective. So beyond the legal representation, what internal resources and the capabilities should companies have in place to effectively navigate the delisting process?
Sure. As it relates, specifically to companies, most companies will have in-house counsel or hopefully compliance personnel of some kind, depending on what industry they are in. It's important when you start a delisting process as a company to have someone who is in charge of that process from the company perspective. We, as outside counsel, are always interested in making sure we know who we're reporting to, how they would like to be reported to. And so when we are doing our portion of the delisting protocol, we have someone who is our constant point of communication. I think that's really important. It helps streamline the process. It helps control costs, obviously, and it helps to make decisions efficiently and quickly as you move through the process. I think the other thing that you want to make sure that you're doing as a company is staying organized and structured. Some examples of that in the delisting space, particularly, is you want to make sure you are keeping good records of the business that you are doing. We call it, in anti-corruption work, we call it books and records, right? But it's really just about making sure you have the documents that you need in a place where you can find them, so that if something does go wrong, you can go back and look at the historical record, figure out, what may have happened and what you can do to try to fix it. We'll talk more about that in a bit. You want to have, you want to make it a team effort, right? You want to make sure that all of your business units are harmonized and operating together to make sure that, you're keeping track of and making records of corporate ownership records, beneficial ownership information, bank records, communications, invoices. If you're in shipping where you're putting product out onto the market, bills of lading, third-party contracts, you want to make sure that you have all of those where they're supposed to be and where you can find them. For individuals, it's a little more complicated, but if you happen to be listed as an individual as opposed to a corporation or a company entity of some sort, it really is the same thing. It's making sure you can get to the documents that you need to show where you were, what you were doing, who you were doing it with, and for what purpose. And so things like travel records, receipts, photos on your iPhone that maybe have metadata to show that you may not have been where you are alleged to have been, or operating with the people you are alleged to have been operating with. So anything that you can think of in terms of documentary evidence, paper evidence that you can put before OFAC during the delisting process is going to be helpful not only to you but to us as outside counsel when we're thinking through the process.
You responded to some of the questions that I will ask actually, but I want to ask how can the businesses proactively assess their risk of potential OFAC sanctions based on their operation and geographic engagement.
Sure. The way we typically approach risk, right, is, I mean, it is in a lot of ways a risk-based approach. You may hear that word if you are engaged with lawyers or counsel who do this often. But really what that means is you want to make sure that you are identifying the issues that you may run into as a company, based on the size and sophistication and industry within which you operate. But when we're doing our initial risk assessment, if we were to come in and say, all right, your company is operating in this region, in this industry, and here's how your transactions look on a typical basis. The things we would be concerned about are, first, geography. Do you do business with customers in third parties, in third countries who are potentially sanctioned, or is it a sanctioned country? Easy examples, of course, are Russia, Iran, and then maybe some of the less known countries that do have current U.S. or other sanctions programs against them, places like Belarus, Syria, China, Sudan. We'll want to see who you're doing business with and in what parts of the world. The other thing is, there are additional risk factors that you look at, not just are they in sanctioned countries, but are these what we call hotspots for actions that are going on. So think about India, UAE, some of those jurisdictions which may not themselves be sanctioned, but where there are a lot of sanctioned entities, and where there is sort of the companies or structures that are intended to evade or avoid or facilitate sanctions violations. You'll want to think about, are those risky places for you to do business? I think for our purposes, Shafik, of course, Turkey, you're going to want to think about if you're a Turkish company. Turkey is surrounded, unfortunately, on all sides, Syria, Russia, Iran, by countries who are in fact sanctioned, and we know that there is business that goes on, and probably legitimate business that goes on in some of those places. But you'll want to think about who you are interacting with and for what purpose. The other thing is your operation or industry. There are obviously high risk businesses that you can be involved with. They can include exporting and importing oil and gas, chemicals, if you're in the military or defense space, or producing dual use equipment, meaning it can be used for civilian or military purpose, industrial machinery, technology, and other sensitive or high value types of industries. You're going to want to be thinking about that, because those obviously are higher risk, because those are the things that companies or countries or individuals who are sanctioned are looking to get their hands on. The other thing you're going to think about is in the stream of your transactions, right? The way that you do everyday business. Are you doing it in U.S. dollars? U.S. dollars are always a hook for sanctions purposes. Same thing with, for example, the euro, or if you're looking at other sanctions regimes outside the U.S., your use of that particular country's currency is a risk factor. Are you using U.S. vendors or vendors in other countries who run sanctions programs? Do you have assets or bank accounts there? And then for the U.S., are you a foreign subsidiary of a U.S. company? Do you have employees who are U.S. citizens, dual citizens, U.S. and some other nation? Or do your employees who are engaged in your business have green cards in the U.S.? If those are all true, or any of those are true, then you have risk of being hooked into the United States for purposes of sanctions, and OFAC and other enforcement agencies could use that as the basis for which to add you to the sanctions list or take other action.
Mm-hmm. Right. What are the key steps businesses can take to mitigate the impact of the sanctions while pursuing the delisting, including alternative trade arrangements or compliance measures?
Sure. So, of course, I think it goes without saying, we as lawyers and I think most people would tell you that you certainly shouldn't be violating sanctions or trying to avoid, evade, or facilitate them. But there are some things that you can do that are legal and are acceptable. And I'll put them in three R's, right? One is restructuring, one is remediating, and the other is rethinking. And I'll explain in a minute. But for restructuring purposes, if you are doing business in a place where there is a sanctions risk, or you have been, in fact, sanctioned for your operations in a sanctioned country, but you are not headquartered or based there, you have the opportunity to potentially restructure your business to avoid some of those risks and making sure that you are separating your US facing or EU facing business from the business that is operating in the risky area. And so making sure that you have some structure and purpose behind the way that you have built your company or your business is important. The second one is remediating. Remediating, of course, is if you are able to identify that there is a problem, what do you do to go about fixing it? And there are lots of ways to do that, right? It's, do you change the way that you run that business unit? Are you using different currency? Are you making sure that a certain type of product is no longer shipped to a jurisdiction? Limiting, sort of putting up guardrails for the way that you're interacting in a place. Also, testing and auditing and strengthening your compliance program if you have one, and if you don't have one, putting one in place that'll help you identify risk, mitigate the risk, meaning trying to avoid some of it, taking action to put it into a place where it should be, so that if there is the possibility of sanctions or there is a listing at a point in time, you can go to OFAC and tell them, here is what we've done to remedy the situation. The third one I said was rethinking. I mentioned this earlier, rethinking your business. How do you structure your contracts? How do you organize your business? And frankly, should you be doing business in a place, or is it worth walking away from, shuttering, spinning off that particular line of business, thinking through, how much profit does it really bring our company? Is it really worth the risk to continue to do that at, and it's affecting the other things that potentially are more profitable. And so really thinking through, is this something that I want to be doing? And if so, how do I want to approach it in a way that is not viewed by the US as being violative?
According to your experiences, how can the companies integrate the listing considerations into their broader risk management and compliance frameworks?
Well, I think the first thing is you want to, the objective is to avoid listing, right? In everything that you do in compliance and front-end maintenance, the prophylactic sorts of things that you do when you're thinking about this, the number one goal, obviously, is to avoid a sanctions violation, and worst of all, being designated as an SDN or on one of the lists that OFAC keeps for various purposes. I think you'll also want to, in your broader risk management and compliance framework, you're going to want to understand the compliance expectations from OFAC, from the Department of Justice, from the Bureau of Insurance and Security, from the EU, the UK, the UN. You're going to want to understand what is it that they are concerned about, not only from a practical perspective, but from a policy perspective. You're going to want to think about how do I justify what I am doing as a business against the backdrop of what they are trying to accomplish through the implementation of certain sanctions, and build that into the risk-based approach that you are taking to your compliance and risk management function. And then you're going to want to monitor activity, and like I said earlier, this will be a theme throughout, is you're going to want to keep meticulous records. Building those into your compliance and risk management programs are critical things. You cannot have, a fully functioning compliance program without monitoring and maintenance of records. And so you want to keep those things in mind and build those in from the very beginning.
Mhm. Mhm. It's also very, complicated by means of the guidances and for those who are seeking, for the businesses who are seeking guidance and information on the delisting procedures, what are the resources available?
Yeah, so there is a lot of information out there, and the easy places to go, of course, are to the OFAC website or the OFSI website. There are many websites out there, but for purpose of our discussion, I'll talk about U.S. sanctions. So the OFAC website has a tremendous amount of information on it. Now, that's a double-edged sword because even though you can find the answer probably to most of your questions, it will take quite significant effort. And there is a lot of nuance and some gray area in terms of interpretation that goes along with that. But for many things, you can go to the OFAC website and the FAQ section. They have a substantial FAQ section in relation to all of the sanctions programs that the Office of Foreign Assets Control run, and those can answer sort of many of your questions if you're just looking for some guidance. I think the other thing is the OFAC helpline, and they have the opportunity or offer the opportunity to call them and ask them particular questions. In my experience, I have found that that's helpful in some instances. In other instances, it is decidedly not helpful. They're not always willing to give you the answer that you're looking for, particularly if you are asking a very complicated question. They can give you guidance. They can tell you some high level things, but they're not going to answer, very fact intensive or serious questions about whether you can engage in a transaction or not in every instance. I think the third source of information, and maybe the best source of information, is going to outside counsel. I don't say that selfishly. It really is. A lot of the stuff that I find out about OFAC, or when I have a question, even I go to the lawyers who do this kind of work. We often engage in conversations with clients or potential clients to talk through an issue or discuss a transaction. Can we do this? Can we not do this? Often you can find a fairly simple answer to some of those questions, but if you need, a further deep dive before you engage in something that may be risky, of course, we'll tell you that and give you the guidance that you need.
And by means of the secondary sanctions, how does the increasing use of secondary sanctions by the U.S. impact the delisting process for companies operating in sanctioned countries?
Yeah. Well, I mean, getting right to the sort of the second part of your question, delisting for companies operating in a sanctioned country. Look, if you're operating or located in a sanctioned country, the delisting process is difficult to begin with. You are already sort of digging yourself out of a hole, and so you'll want to be mindful of that. If you're a foreign company with operations in a sanctioned country, so you have a factory or some sales office or some other operations within this sanctioned country, you're obviously going to have to carefully consider what your next steps are. And it will often involve that thinking process about what do I do with that business unit? Do I keep it? And if I keep it, how do I make sure that I'm compliant through structuring, through making sure that you're using the correct currency, through making sure that the product that you're selling is not itself prohibited. Or you may want to think about spinning off, that particular business in that particular country, and then focus on those areas of business where you don't have as much risk. That it's an appetite question for any company and their executives when you're going through that. If you've already been listed, but you think you have a legitimate claim to being delisted, you'll want to consult with outside counsel. Obviously, that's a very difficult situation to be in. We'll talk in a little bit about what are the considerations for being delisted and how can you make the best, the best case for yourself. And there's a lot that goes into it, including some nuanced policy arguments that you probably will want to make. But consulting with outside counsel and coming up with a plan to be delisted, if you can. And of course, there have been instances where we've told potential clients that it's sort of no matter what you do, it's unlikely that you would be delisted, and we don't want to waste your time and money. The increases in importance on keeping records and making sure that you're following through with your compliance obligations. Importantly, it is not enough to say that I'm a foreign country doing business. I'm a foreign business doing work in a foreign country with foreign customers, offering foreign services and products. There are many companies on the SDN list, another list maintained by the U.S. government, that have been sanctioned with minimal U.S. contacts, and in some instances, no contact with the U.S. Right, and that's really the definition of a secondary sanction. It's you can be sanctioned with having almost no connection to the U.S. at all. And a secondary sanction by definition is really just being added to a sanctioned list where your property is blocked, which means that U.S. banks and frankly other banks around the world will not allow you to engage in business with them. And so it blocks you out of the U.S. financial system and potentially other financial systems around the world. And so it's very difficult for you to continue to do business that way. And the risk of secondary sanctions now is probably greater than it has been in the recent past, given the number of places in the world where there are particular issues that the U.S. government is trying to deal with. And a good example of that is just last week, the U.S. government, the Department of Justice, OFAC, and the Bureau of Insurance and Security put out what they call a tri-seal compliance notice. Really what that means is all three of those agencies have gotten together and have written a document, a several-page long document that talks about something that they think people would be interested in and that they should know. And this particular compliance notification talks specifically about the dangers of foreign companies doing business in violation of U.S. sanctions, and that they would be and plan on taking increased action against those types of companies. And so, of course, you're going to want to be on the lookout for that, even if you are not engaged in business in some way in the United States.
In many cases, I face the question of the potential consequences of failing the sanctions and the OFAC regulations. And I want to ask this question to you. What are the potential consequences for businesses that fail to comply with the OFAC regulations and the sanctions?
Sure. Well, I think the first one is the one that I just said, right, is consequences of failing to comply with OFAC sanctions is listing, right, is being listed as a specially designated national, and what that means is you really can't bank. You can't have money in banks, particularly the large international banks. They would freeze your money in most instances, so you would lose access to the lifeblood of your business, which is your cash flow. You'll note for our purposes, Shafik, I think the U.S. government came out with with an executive order back in December, specifically related to foreign banks, right? Not U.S. banks, but banks operating abroad, that made it very clear that there would be sanctions implications if they continued to run transactions that OFAC viewed to be in violation of their regulations. And so in that instance, there are many Turkish banks and banks, frankly, everywhere, who had been engaged in, even borderline or transactions that were fine, but got close to the line, they have by and large shut those down. And so your ability to bank is gone. Customers and suppliers may refuse to do business with you. If you end up on the list, there are going to be a lot of your customers who you sell to and suppliers who you get product from who are simply going to say, I don't want to do business with you anymore. And so that will be harmful. The reputational harm that comes along with it, right? It's hard to recover from that. The business that you do and your reputation is critically important for the success of your business. And if that is damaged, particularly in such a significant way, it's going to be hard to recover, even if you are able to get delisted. And then finally, you're going to spend, well, not finally, you're going to spend a lot of money trying to get yourself out of the issue, right? There's going to be legal fees and potentially substantial legal fees to try to unwind the problem, depending on how far it gets. There potential for monetary penalties with OFAC or other enforcement agencies. You can go online and look. For most of you who are joining us today, you've probably seen in the news these massive, penalties that companies agree to pay as part of their settlement process, right? If you are, get to the point where you're contacted and have to make a settlement for a particular purpose, there may be significant monetary penalties. And then in the worst case scenario, of course, you could face criminal charges in the US or other places, which would prevent, your executives and other individuals engaged in business with you from traveling, certainly to the US, but maybe other places where extradition may become an issue. And so those are all very serious problems that put you and your company at risk.
Besides, there might be some contractual obligations if you committed to be fully compliant with the sanctions and you failed. That's
Absolutely.
A big loss. Yeah.
More and more contracts are requiring that now too. I think we all see that more and more.
So, Brett, how can the delisting process be streamlined or expedited for businesses that demonstrably pose minimal risk to national security or foreign policy interests?
Sure. I think probably the most salient advice I can give you today, if you are actually considering going through a delisting process, is to hire experienced counsel. I have, I'm sure Shopik has done the same and others. When you do sanctions and export control work day in and day out, you understand the nuance of what it is that OFAC's looking for. You've probably written many of these delisting petitions. You understand how they need to be structured and what information needs to be included, which is not always common sense. You have direct lines of communication potentially to OFAC or other enforcement agencies who you can have a productive discussion with as you go through the process. And you'll have the resources that you need to make sure that you can accomplish those things that you need to do to make sure that you give yourself the best opportunity to be delisted. Be cautious when you're hiring counsel. There are lots of lawyers who say that they know sanctions, but sanctions is not really about reading it in a book. It's about doing it. The experience is important. You want to make sure you get an experienced, lawyer who has dealt with OFAC and the DOJ and other agencies and know how they operate and what to expect. The other thing that you can do, obviously, is utilize your own contacts through local embassies, chambers of commerce, business organizations that you are a part of. You'll want to leverage your ability to show that you are or intend to be a good actor and a good, citizen of the community. And those things can be important in putting your best foot forward when you're trying to become a delisted company. Obviously, like I've said before, I'll say it again, have your documents ready to go. Make sure that you're able to, put your fingers on them, provide them to your counsel, use them to maximum effect, and show in black and white what it is that you did and what you're doing. that warrants being delisted. In some instances, we recommend being cooperative, right? The U.S. government obviously places a huge emphasis on being forthcoming and providing information. You can get a lot of goodwill for doing things like that, and so it's always a consideration. Not everybody wants to do it for various reasons, and that's fine, but it is something you want to think about and explore. The last one I'll say is be proactive. Be proactive in presenting your facts to the agency. Be proactive in remediating your risk. Be proactive in finding the solution to the problem that you find yourself in. When you are listed, there is often a document that says, here are the reasons why you were listed to begin with, and you don't always have notice of that, right? In many instances you do, but not in every instance. So at the time that you start to think about being delisted, you will have information about what it is that they view as being the problem, and you can then solve for putting things into place to make sure that you present your best case.
Mm-hmm, mm-hmm. So I will ask from the company's perspective, for the sanctioned company's perspective, based on the current circumstances surrounding my company's designation, what are the strongest grounds for petitioning for delisting from the OFAC sanctions lists? This question helps understand the most effective approach for delisting based on the specific situation.
Sure. Before we do that, I just want to. I think it's important to say when you think about delisting and you think about whether it's possible or not. I'm just going to read a couple of lines from the OFAC website itself, and they put it on the website, but it's found in some of their regulations. And it says this simply: the power and integrity of the Office of Foreign Assets Control sanctions derive not only from its ability to designate and add persons to the SDN list, but also from its willingness to remove persons from the SDN list consistent with law. And the ultimate goal of sanctions is not to punish, but to bring about positive change in behavior. And so I think that's a good starting point when thinking about what am I trying to accomplish when I'm asking for a delisting. It is you have to think about, why did they list me? What is the activity or thing that I engaged in that caused me to be listed in the first place, and how do I overcome that? So what we've seen is typically most companies are removed based on one of the three following things. One is their improper placement on the SDN list, right? There have been issues about companies being placed who may not have been appropriate for placement on the SDN list. Two is mistaken identity. Perhaps you were placed on the list based on information that was about someone else that was similar or close to circumstances about you. And then the third one is what I was just talking about, and probably the most common reason why people are removed from the list, or a change in circumstance that warrants removal. Another thing to think about is if you were sanctioned for being related to or affiliated with a sanctioned company or person, and you can show through records or other information that that's untrue, or that you have been divested from that particular entity, or they have removed you, either way, that may be another basis. And in fact, there was a delisting for a number of Russian bank executives not long ago, who were originally listed as part of the banking designations that happened early last year. They were ultimately removed because they had resigned from their position and moved to a new country. And so it took some time, but ultimately they were delisted. Mistaken identity, obviously, going back to what we talked about before, you're going to need documents and proof. It's really your burden to prove that you are not the person they say you are. So that's important. And then for the one that's most common, which is change in circumstance, right? We've filed delisting petitions for many companies and individuals, not just me, but our firm generally, for myriad reasons, but they almost always include some element of remediating, right? Remediation, which basically means you have to identify the problem and put controls into place so that it doesn't happen again. And then it's owning up to what happened. Two, it always involves some element of investigation, understanding, going in and pulling the documents and looking at the emails and seeing what happened and understanding why and how it happened so that you can do the remediation portion of it. And and we've done for individuals, we've had them take, sanctions training programs. We've had them engage in getting certificates showing that they understand now what sanctions are and violations of sanctions. We've had them resign from their companies. We've had companies have individuals removed from the company structure. We've done restructuring for companies and setting up different business units to help solve those problems. So if you're looking at a listing based on a certain behavior, OFAC says if you change your behavior, you should be delisted. And so part of our job is to identify how we can change the behavior to the satisfaction of OFAC so that you can be removed from the list.
So that's the issue. What evidence needs to be compiled and presented in the delisting petition to demonstrate that the grounds for the removal are met?
Yeah, so just in terms of documents, we've presented in the past emails, phone records, travel records, bills of lading, WhatsApp communications on occasion. We have submitted certificates, like I said just a moment ago, certificates, showing that someone has completed a sanctions training program. We do presentations related to the way that the compliance function's been remediated. We have, recently, we're engaged in one now where there were documents as part of a court process that were found to be fabricated. And so we were able to identify that. And now we are submitting the evidence to show that the listing was based on, at least in part, a government document that had been fraudulently changed. There are lots of things that you can put in front of OFAC. The other thing that you're going to want to put in a delisting petition is a discussion about, why was I sanctioned to begin with, and what are the policy reasons for me being delisted, right? And those can be varying based on, which sanction program you were listed under. Sanctions related to Russia are different than sanctions related to Iran, which are, again, completely different than sanctions related to other places where they may have a program running. And so you'll want to think about putting that evidence or that argument in front of OFAC to help them understand where you're coming from and get a color to the way that you're engaging in transactions, that it's not always what it appears.
Mm-hmm. Right. Is there a specific timeline for the listing process? And what are the key milestones and potential delays to be aware of?
There is not. OFAC says that when they receive a delisting petition, they attempt to have their first, and just stepping back a little bit, the way the delisting process works, just as a practical matter, is, and I'll walk through just a scenario where, for instance, someone has come to me and hired me to help them get delisted. We would come into the case, we would have, a series of questions to understand what happened. We'll review the documents. We could potentially engage in some investigation to get some more information about how things happened and who was involved, and for what purpose it was done. Ultimately, that all ends up in us writing what's called a delisting petition. It's a written work product that it has all the arguments for why you would want to be delisted. you attach supporting documents or evidence that you want to be considered, and you send that to the OFAC delisting email address. What will happen is you'll get a confirmation that they've received it and forwarded it on to the correct unit, and then you wait. At some places, we, for instance, thankfully have some communication with OFAC. And so while they're not going to tell us exactly where in the process it is or what they're thinking is necessarily, we can engage sometimes in conversations with them to get updates. But essentially you wait. What typically will happen is they will send you a questionnaire. A questionnaire will have questions about, the overall petition, may have specific questions about your company or you as a person. It may address certain things that you said in your delisting petition and ask for more information or ask for more documentation. You have typically 90 days to respond to that. And that process goes on until they feel like they have enough, and they'll send another questionnaire, and that process continues until they feel like they have enough information to make a decision. So in terms of timeline, you'll get a response right away that they have received your petition. They try, although they are not always successful at getting you a questionnaire within 90 days of your petition being filed. But after that, it sort of depends on how complicated the issue is, how much information you've provided at the outset, and what questions they might have to be able to make a decision. I'll note that OFAC is pretty understaffed. I think typically, in my experience, it takes months and months to get a final decision. But you should obviously be prepared to wait, particularly in complex situations or where you're making an argument about making mistaken identity, or in the case of fraudulently created government documents. Of course, all of that is going to take a long time for them to get their arms around. So you can expect it will take some time.
And is the final decision subject to appeal?
So it's technically it's not. But there are other procedures in which, excuse me, in which you can engage. Particularly, it has been done where you engage in filing a lawsuit under the Administrative Procedures Act or the APA. And basically, what that would do is you would, in essence, sue the government or OFAC for a wrongful delisting and put that out there, and they would have to respond, and a court will make a decision. Two examples recently, I mentioned earlier the Russia issue with the former executives of a Russian bank. My understanding is that was taking quite some time, and so the law firm engaged in that filed an Administrative Procedures Act lawsuit against OFAC, and then OFAC ultimately delisted before that lawsuit proceeded. I'll also note that I think just not long ago, in last year, middle of last year, there was I think the son of a Russian metal manufacturer, the owner of the company, his son was listed as part of the initial tranche of Russia sanctions, filed a lawsuit in the EU. There's a similar procedure in the EU. Ultimately, the court there decided that he should not have been listed. And so there are things you can do if you're ultimately denied through the delisting process at OFAC.
Mm-hmm. What are the potential risks and the financial implications associated with pursuing the delisting?
In terms of risks, it's hard really to identify a risk necessarily, other than to say, in the unlikely scenario that, for instance, you or your company were designated under Russia sanctions, but you were engaged in business also in Iran that might be violative, and as part of the process, it comes out that you also were in violation of Iran sanctions. But at that, it's hard to say that that's that risky because you were already sanctioned to begin with, and so you haven't really put yourself in any worse spot necessarily. My philosophy is really it doesn't hurt to ask, right? The only downside to me, I think is the cost, the expense and time involved in a delisting procedure. And again, I go back to, there are some situations where it is just so unlikely to be delisted that we would tell you that, and save you the tremendous cost that it might take to get down the road and just be told no anyway. On the issue of cost, we've seen individuals and companies try to pursue delistings on their own to save money. My view on that, though, is that the process, though it may seem straightforward, is not so straightforward. In the long run, you ultimately end up paying more money to try to unwind some of the things that may have been done either through you individually or internally, or through hiring lawyers without significant experience in this particular field. Don't My advice would be, don't risk engaging with OFAC without external counsel. That there are lots of things that they're going to ask. There are lots of legal implications. There's privilege that you're going to want to protect, because keep in mind that anything that you do with OFAC, there is the lingering possibility of criminal sanctions out there. You don't want to say something that's going to get you in more hot water, really. And it's really worth it, in my opinion, because what we can do in a very short time, because we've done it so much, right? We can pull from prior delisting petitions. We can put together arguments and proposals to your company to try to take these things to the next level very quickly. So it's important to make sure that you get good advice. We also may, in some instances, recommend that you wait for a period of time. We may advise you to take certain actions to put yourself in the best position to be delisted. There are things proactively that can be done. So really the risks are very minimal, but the cost involved can be quite astronomical if you don't give it your best shot and are efficient the first time around.
Are there any alternative strategies such as licensing or mitigation measures to minimize the impact of the sanctions on a company's operations?
Yeah, absolutely. So there are licenses, right? Of course, there are two major kinds of licenses, right? A specific license and a general license. A specific license is a license that you request and are provided with for a particular transaction or series of transactions. And so if you know that there is something that is sanctioned that you want to do, you can go to OFAC and say, listen, there are these particular series of transactions that I want to engage in that would otherwise be prohibited, but here are the reasons why we think it makes sense and is consistent with U.S. policy and is not going to cause damage or evade or avoid the purpose of the reason that the sanctions were imposed. And we would like a license to engage in that transaction, meaning they give you specific permission to do it. And so that's an easy way of going to try to get information. Now, again, that takes time and some effort and some cost. But in the long run, if there's something particularly risky that you think, is within the parameters of being appropriate, it might be a good idea to go to get a specific license. A general license, on the other hand, is not something you have to ask for. They are licenses that OFAC just puts out for particular purposes. An example is, often I, as a lawyer, a U.S. lawyer, will have to operate in representing a sanctioned person under a general license. They say, I can represent this person who is sanctioned for getting delisted, providing sanctions compliance advice, or otherwise advising them on U.S. law in front of U.S. courts, agencies, or enforcement groups. And then there are certain rules that go along with that. But for companies, you'll see whenever they come out with a new, particularly wide-reaching sanction or a new sanctions program, like we saw after the Russian invasion of Ukraine, where they have certain wind down periods or they allow certain energy transactions, or certain other types of the buying and selling of uranium, for example, where you can engage in that certain type of business for a limited purpose under the rules that they give you. And so that helps you to mitigate, the risk of those sanctions on your company. And so you'll want to get advice about those. Sometimes they are complicated, and there's a bit of advice that needs to go along with that. But if you can operate in one of those two ways, that can significantly decrease your risk and drive costs down for you. Business structuring, not evasion of sanctions, but actually, structuring your business in a way that walls off certain risks and builds out your internal procedures so that you can separate, business units in a way that helps you do that. And those will minimize, what you're trying to do versus the risk that may be involved in that.
Mhm. I have some questions for the legal professions, actually. What are the most common challenges that legal professions encounter while representing clients seeking delisting from the OFAC?
So I'll just speak from personal experience. The reason I hammer on having your documents in order is it's very difficult for us as lawyers to help you if we don't have the information with which to help you. So I think, one of the big challenges is if you're advising, companies, and if you're in early enough to help that company understand that they need to, maintain their records, you should be doing that. It makes life so much easier if you can ask questions and ask for, documentation to back up the allegations or the arguments that you're going to make. It makes life so much easier. I think, another difficulty is, frankly, we've talked about this before too, is having to undo some damage that may have been done if you didn't engage with your lawyers from the very beginning, right? If you're going down this path and things have been submitted to OFAC and certain things have been said, and having to, step that back, you risk losing credibility. You risk it not being delisted, frankly. And so it's important to make sure that that you and the council really doesn't have any control over this necessarily, but to the extent that there are people who may hire counsel for this, they should bear that in mind from the very beginning. I think the other challenge is just the perception of a person once they've been listed, right? Is how do you help, because we think about it, obviously we want to get you delisted. That's the legal barrier, but there are other issues that we have to deal with as counsel, right? Reputation and image and the way that you do business, and making sure that you can still carry on a viable business while dealing with these issues that you've got going on that are very consequential. And so we try to think about it from a very business minded perspective. And so those can be challenging because lawyers aren't always thinking about the bigger business picture while they're thinking about, their very narrow legal issue. But I think that's a very important part of the representation, particularly in this context.
Mhm. By means of gathering and presenting the evidences to support the delisting petition, how can legal teams effectively do that?
Yeah, that is a discussion unto itself, I think. But just at a high level, there are in the U.S., right, for example, data privacy laws. But I would suggest that the data privacy laws, for example, in Turkey, are much more restrictive. In the EU, they are much more restrictive. They are by an order of magnitude more protective of personal information. What we as counsel often do, depending on the size of the company and how sophisticated they are and how they maintain their records, and to keep privilege and not send files back and forth unnecessarily, getting counsel involved to maintain the privilege is important. Having us hire your outside vendors so that they are operating under our direction, which also helps maintain privilege. Setting up data rooms, right? If you want to keep all of your information internal, there are ways that we can have outside vendors and others who can extract information, put it in a place where we can access it, but it is not accessible in any other way. And so thinking about how you transfer that information to protect you in worst case scenarios is very important. You're going to want to involve as few people as possible, right? I mean, you need the people that you need, but having a person designated, I said this, I think the very first question, having a person in the company designated who's in charge of the process. You may want to set up an independent spinoff of the board, right? A special committee of the board of who is the person that we report to, particularly if you think some of the current executives may have been involved in some of the stuff that got you listed in the first place. You'll want to, not widely, discuss with people at the company what's happening. You'll want to have your internal counsel be the point of contact for information coming in and out. So all of those things are things that you want to think through on the very front end, particularly if it's a very serious issue where you think that the listing is not the only problem, that there may be follow-on enforcement action or administrative action by the U.S. or other agencies. And then, talk about those from the very beginning. Don't start sending stuff back and forth. Make sure you control that process right from the very start.
Thank you, Brett. We have a question from the audience. Says, what kind of benefits an insurance company can have regarding delisting or getting a license?
Well, for an insurance company, right, sometimes insurance and reinsurance are sanctioned, and that's true, I think, in the Russia sanctions and maybe others. If there is a particular type of insurance that you're looking to provide that is within the gambit of what the U.S. policy is looking to control, or whoever, EU, then if you go and get a license and say, I want to be able to provide this certain type of insurance, and here's what it's going to be for, here's how I'm going to document it, here's how it's going to be paid for, and here are the reasons why that is appropriate for policy reasons, then you may be licensed within that narrow framework, right? Of it, like, here are the guidelines I'm going to follow when I engage in this, to sell that particular type of insurance or provide that particular type of insurance. It really is just, I'll call it a hall pass. I don't know if that translates well, but it's a I've told you what I'm going to do, and you have told me that that's okay within these particular set of rules. And if I do that in the way that you told me to do it, then I will not be in violation of sanctions and carry on that business. And so I think, getting a specific license is critically important if you are intending to engage in an activity that is really even close to the line of a potential sanctions violation, and especially if you're doing it in a place where sanctions are nearby.
And one last question from me: how can the legal professionals stay informed about the updates to OFAC regulations and guidance to best serve clients navigating the delisting process?
So a few things. One is sign up for OFAC emails. You go to OFAC's website, they will send you an email, typically on Friday afternoons, but sometimes at other times, where they will, they'll update you on significant guidance. They'll update you on listings and delistings, and those will help you sort of stay abreast of what it is that they're focused on and what they're trying to do if you pay attention to them. You can sign up for updates from different law firms. Our law firm, for example, sends out periodic updates related to, we sent one out about the Tri-Seal compliance notice with a copy of it. We send them out when there are big designations There was one recently. We did the 7 takeaways for the most recent Russia sanctions designations. So you can get information from law firms who do this on a regular basis. You can sign up for specific sanctions or export control newsletters. There's Global Investigations Review has a sanctions area. There's World ECR, which is a newsletter that deals often with sanctions and export controls. So there are different newsletters that you can read. There are certain LinkedIn groups that talk about these kinds of things, or people who are, that do this often, that write about it. So you can follow those. You should, try to look weekly or so at OFAC and other U.S. agencies' actions during that period of time, because they will come out with enforcement actions against companies or individuals. So those, and they will explain the reasons why they did what they did, and those are very informative, particularly if you can find one that, is similarly situated to you or your business. And of course, finally, if you need recommendations for certain things, or just want to have a chat, call Shop-it, call me. We have a list of websites and newsletters. We're happy to get on the phone with you for free to just have a conversation about your issue, to see if it's something, we can point you in the right direction, or something we can help you with. Don't be afraid to reach out. That's what we're here for.
Thank you, Brett. It was very insightful conversation again, and I hope that we can organize more webinars and the similar topics. And thank you for everyone. The audience was great. We have almost 155 people online, and thank you for everyone who joined us today. Thank you.
Thank you, everyone. Thank you, Shop-it.